Thank the chair, and I thank the witnesses, and good morning to each of you. Want to quickly go to Mr. Kirshner here and just simply ask if you had anything to add about Ms. Graves' testimony. It was characterized that you agreed with what she was saying in that early line of question. Did you want anything else on the record?
My statement is that to the extent that a hospital or rather contractor has an obligation to prove, as a bona fide contractor, to comply with an affirmative action program, I think that is legitimate. But what I don't think is legitimate is that if a hospital signs up for a contract and is told in that contract that they're not a federal contractor, has no clear knowledge that they are a contractor, and then after the fact, the OFCCP comes in and says, oh, by the way, for the last X number of years, you may not have known this, but you were a federal contractor and you've been out of compliance with the law for years. That's the situation we are trying to clarify, and with support of this bill, to make it clear that providers under these federally funded health plans are not federal contractors.
Yeah, that we're going to follow the rule of law, not the rule of men.
Right.
Yeah, I'm getting that sense here at the hearing today. It's a shame, though, and I associate my comments with the full committee chairman that we have to say again what we intended the first time. Mr. Goldstein, you note in your testimony, you talked about the Florida Hospital of Orlando case, and one of the reasons we're here today is that the board took what you say was an unprecedented action. The ALJ, if I understand it right, the ALJ initially agreed with the hospital that they weren't going to be contractors or subcontractors, and then the full board, the review board, then kicked it back down where it now sits at the ALJ level. Can you expand on that? Why is this so unprecedented?
What happened is the Administrative Review Board originally agreed with Florida Hospital and found that OFCCP did not have jurisdiction because of the congressional action. It was done, and it would have resolved the issue, and it would have been clear TRICARE does not create OFCCP jurisdiction.
Yeah.
OFCCP asked the Administrative Review Board, which basically represents the judgment of the Department of Labor, asked it for reconsideration, which in my experience...
Oh, that is unusual.
In my experience, that's very unusual.
Okay.
If not unprecedented. And the ARB granted that reconsideration, which again is very unusual, if not unprecedented, and in a divided opinion, found that this act of Congress did not, in the judgment of 3 of the board members, divest OFCCP of jurisdiction, sent the case back down to an administrative law judge for further proceedings, basically delaying the final day when a federal district court gets to determine what did Congress actually mean when it enacted Section 715.
So when you say unprecedented, do you mean that it's unprecedented within the jurisdiction and precedential decisions of the Department of Labor's Administrative Review Board, or within federal government agencies as a whole?
To my knowledge, within the ARB, I don't know the answer with regard to federal agencies as a whole.
Okay. Thank you. Mr. Corrado, thank you for your testimony today. The Department of Labor, of course, and the reason why we're here, asserted TRICARE providers are subcontractors of the federal government. I guess what I'm wondering, though, and I want you to expand on it, they seem to be the moose on the table, the Department of Labor, but do other federal agencies consider TRICARE providers to be federal contractors? I mean, that is to say, are there broader issues associated with the OFCCPs?
There are much broader issues, and I think historically this question has come up as to how to classify providers. And in addition to OFCCP regulation, there are a host of flow-down provisions that would flow to federal contractors. You know, the FAR, the DFAR, which requires certain cost accounting systems, disclosure statements. So there would be, if TRICARE providers were indeed classified as contractors, there would be a host of additional burdens. So to my knowledge today, no other federal agency, to include the Department of Defense, considers them subcontractors.
Oh, I'm just thinking about this. I guess that if they were considered ultimately legally contractors or subcontractors, now they'd be subject to the President's new executive order on raising the minimum wage.
Correct.
Which would have costs as well.
All flow-down provisions.
Right. Mr. Kirshner.
Yeah, if I may, If I may just add to that, the Department of Defense actually has its own regulation classifying providers in TRICARE as not federal contractors. So it's not just that they haven't taken a position, but they have taken a position in contrary to that taken by the OFCCP. And the Office of Personnel Management similarly has a regulation classifying participants in the FEHBP program as not federal contractors, and the OFCCP has disagreed with them as well.
Rule of law versus rule of man, Mr. Chairman. I yield back.